something more humane which grants them dignity. The majority opinion opposed adoption rights for same-sex couples too. In fact, listen to the Chief Justice in his own words. Listen into how he, of course, came out in support of the same-sex marriage.
Queerness is a natural phenomenon known to India since ancient times. It is not urban or elite. C. There is no universal conception of the institution of marriage, nor is it static. Under Articles 245 and 246 of the Constitution, read with entry 5 of List 3 to the 7th Schedule, it lies within the domain of Parliament and the state legislatures to enact laws recognizing and regulating queer marriage. This court cannot either strike down the constitutional validity of the Special Marriage Act or read words into the Special Marriage Act because of its institutional limitations. This court cannot read words into the provisions of the SMA and provisions of other laws, allied laws, such as the Indian Succession Act and the Hindu Succession Act, because that would amount to judicial legislation. The right to enter into a union cannot be restricted based on sexual orientation. Such a restriction will be violative of Article 15. Thus, this freedom is available to all persons, regardless of gender identity or sexual orientation. The union government, state governments, and governments of union territories shall not discriminate against the freedom of queer persons to enter into union with benefits under law.
As I said, viewers, the CJI's was a minority judgment. Only one other justice on the bench sided with him, 3 others opposed him. Obviously, the rights activists are not very happy. Listen in to what they had to say.
Clearly, one is disappointed, right? And the disappointment is not that somehow I at a personal level, thought that even if full marriage equality rights are not given, at least some kind of civil rights would be given, civil unions would be accepted. So it's really sad that even that didn't happen.
Every judge put the onus on the central government and the state government to formulate rules. So if you are in a constituency, please, if you are from the LGBTQI plus people, or you want to show your support to LGBTQI plus people, please go and speak to your elected representative. Tell them that you will vote for them if they stand up for this, and if they don't stand up for that, please vote them down. Let them also know what going against queer love would actually mean.
We have a special marriage act. The petitioners demanded our marriage right in that particular act, but the honorable judges and union government again considered these things in a religious tone.
Clearly, viewers, you've heard those reactions. Some feel that the Supreme Court played the role of a facilitator, took concerns and put them in the ambit of Parliament. Now, history tells us that the Supreme Court has not always respected the doctrine of separation of powers. Here are some examples when it was accused of running roughshod over the principle. On the issue of the ECI appointment matter, the Supreme Court ruling on appointment by President via panel of PM, LOP and CJI, that's what it said. Government says no law via Parliament. Asked SC to show judicial restraint, basically saying that, look, we haven't even come out with this law, you can't promulgate one on our behalf. Article 324, the government said, highlights the role of legislature for election-related laws, and therefore this falls very much within our remit. Then was the issue of, in 2016, of highway liquor ban. You would remember that, viewers. It touched a raw nerve amongst those who were frequenters of bars, etc. The SC banned the sale of liquor within 500 meters of national and state highways. A large number of state governments said that no proof was presented to link liquor sales near highways to accidents, and a number of them criticized the Supreme Court for, in their words, flagrantly breaching separation of powers doctrine. So that happened too. Then in 2015 came the NJAC verdict. The Supreme Court rejected the NJAC Act to empower politicians and civil society to appoint judges. Parliament had decided to go ahead with that. The SC ruling reaffirmed the supremacy of the collegium system. The ruling was criticized for ignoring vested interests of the judges. You remember this very clearly. It became a massive point of contention. In 2005 cash for vote scandal, Lok Sabha Speaker Somnath Chatterjee ignored the Supreme Court notice of expulsion of MPs. He claimed that he was performing his constitutional duty. Chatterjee questioned the authority of the SCO exclusive domain of the Lok Sabha. And of course, viewers, there was also the Visakha guidelines. They were put in place. Of course, it was a very progressive legislation, progressive policy decision. But nonetheless, there were a number of people who raised eyebrows back then. But let's get a sense from some key stakeholders of what really transpired today. And we are joined by Mr. Mahesh Jethmalani. He needs no introduction. He's a member of Parliament, Rajya Sabha member of Parliament, supported by the Bharatiya Janata Party, member of the party, and also, of course, a noted legal mind in his own right. Mr. Jethmalani, thank you very much for speaking to me. I want to ask you directly, straight, without any of the usual caveats, does this cause lack a strong case, point blank?
You know, Rahul, everything really turned on whether the court held that the right to marriage was a constitutional right. If it was a constitutional right, then, you know, if the court did recognize it to be a constitutional right, that the right to marry flowed from the Constitution, then things would be quite different for the LGBTQ community. They would be on a much better wicket. But, and this was always going to be an issue, if they found, in fact, the minority judgment, Justice Chandrachud, the Justice called, they held that it was a civil union, right? The majority judgment held that neither the right to marry nor even the right to enter into a civil union, which is, I suppose, a union akin to marriage, but not exactly marriage, right? Neither of them flowed from the Constitution. Now, that being the case, what they impliedly said, and actually what they explicitly said in parts of the judgment, was that this flows from statute. Your right to marry or your right to enter into a civil union, right, both stem from statute. Absent a statute, right, the courts can't recognize it. It is in the domain of Parliament and the union government. So that's where, I mean, you know, that's the point one was looking for in this judgment. If you escalated that right to a constitutional right, then yes, the LGBTQ community would be in business. But having restrained themselves from going that far, right, you are left with a situation where a right view that is gone back to where it always belonged, i.e. to the domain of the legislature and the executive. And they will have to now legislate. The good thing for the LGBTQ community is that, and not transgenders, because transgenders have a right to marry already, but the other categories, the good thing for them is that the Supreme Court, the majority judgment, has asked for a high-powered committee headed by the Cabinet Secretary to go into all issues as expeditiously as possible concerning same-sex marriage. So to expedite them, and if they can be brought on par, really, you know, some way or the other. Because the existing statutes on marriage, the Special Marriage Act, the Hindu Marriage Act, all the, you know, religious acts, none of them allow any construction for same-sex marriages. They are very clear in their definition of who is capable of undergoing the ceremonies requisite for a marriage. And unfortunately, people belong to the same sex do not come within the language. You'd be torturing the language of those statutes.
Of course, I'll come to the Parliament's role in just a few moments, but I want to ask you, because this was raised in court also by the AG and the ASG. They said that, look, the Supreme Court shouldn't have even gone into this matter in the first place. Do you think, in hindsight, the Supreme Court could have well steered clear of this?
Well, you know, I mean, Rahul, the fact of the matter is, you know, we are trying. This is the age of inclusion, right? So the Supreme Court felt that there was and you know, as Justice Chandrachud pointed out in his judgment, this is not just an urban phenomenon. It's not an elitist, category of people. So it's quite widespread, and we want to include them if possible. So if they were examining it, There was a petition before them. They had to deal with it. Right? They can't say without looking into it. Right? It's not that the law is somehow or the other buried in their chest that they have to spill it out. Right? They have to hear parties, hear the rival contentions, right? And ultimately, after a searching examination of the whole issue, right, they came to this conclusion, which they finally did. And there were split verdicts. One was slightly more liberal in the sense that they said at least civil unions are permissible. The other was, a strict constructionist view that any kind of relationship requires statutory intervention. That's how it broke up, really. So you can't blame the Supreme Court. To answer your question, it would be extremely unfair to blame the Supreme Court for taking up the issue.
Okay, so let me then extend that logic, because what has actually resulted from all of this is that the Supreme Court has upheld the principle that the majority therefore must decide. It's given the baton now, passed it to Parliament. And if it is the age of inclusion, why won't Parliament then do what is expected of it, which is grant these people their dignity, their rights? Has the time come?
Look, if I give you an answer right now, it will be a prescriptive answer. It will be my own personal view, right? So, Parliament, when it passes legislation, right, and it's really, far-reaching legislation, which is a clear break from the past, requires to hear all stakeholders, not just those who will benefit from this legislation, but also, stakeholders who have an interest, sometimes a vested interest, religious community. I mean, for instance, the Muslim community, the All India Muslim Personal Law Board was dead against, extending these rights. So they have to be heard. Every stakeholder has to be heard in this matter, and that's what Parliament will do now. They've heard the request of the Supreme Court, set up a high-level committee, and they will expeditiously be calling all stakeholders to see whether it redounds to justice, fairness, etc. Right? But before they have to give natural justice to those opposed to this issue as well.
Obviously that is the way things work in Parliament. But fundamentally, Mr. Jethmalani, one of the reasons why a large number of those who stand on the side of inclusion are feeling a bit despondent today is because the government of the day, which is in the majority, has already taken a stand against this issue very clearly in court, number one. Number two, the fact is that Parliament has never or has seldom stood, there are a few examples, seldom stood really, as a champions of progressivism, societal progressivism. I mean, you've had the Shah Bano example, and we see how the Parliament tied itself up, or that government of the day tied itself up in knots. So clearly this is now, the door is shut really, isn't it?
No, the door is not shut at all. I'm sorry, the door is not shut, Rahul. I mean, there's plenty of hope. Let's see what the high-level committee says, what the recommendations are, right? So I don't see that being shut at all. I just see it not being rushed through. That's all. I would say that the way to interpret today's outcome is to say that the Supreme Court has wisely and rightly eschewed jurisdiction because it rightly found that it had none, right? So it has eschewed jurisdiction. It has not pervaded. I mean, we often complain that, the Supreme Court is trespassing into the domain of the legislature, right?
Yeah.
Now, today when they eschew it, right, you can't blame them. They found that this is a matter for weighty construction by those who are endowed by the Constitution with the power to legislate.
Thank you, Mr. Jethmalani.
And they will do it in their own manner.
Okay, thank you very much. I think you put your point across. Let's open this up for further and wider debate. Thank you very much. That was Mr. Jethmalani joining us live there for that one-on-one interaction. I just want to open this up and go across to our other guests also. The NCPCR chief is here with us. But before we do that, viewers, just a quick reminder that the big question that we are framing is going to come up on your screens. Lip service paid to the cause of social justice tonight. Is that what really happened? And is that what is going to happen?
Hello, Moto.
It brought to you by Motorola. Have a look at that. Gay marriage verdict, lip service to equality, to social justice. Let's open this up. Let's get into this. We have some very, very, very imminent panelists tonight. Karuna Nandi being one of them. J. Sai Deepak. We also have with us Hitesh Jain, who has taken a very strident view on this issue on Twitter, which has found favor with, of course, those in government also, and many others who believe that the Supreme Court was perhaps, as Mr. Jethmalani said, exceeding its brief at one particular point because it didn't have the jurisdiction to do so in the first place. Mr. Kanungo is also there with us, the NCPCR chief. Thank you very much for speaking to us. Mr. Kanungo, let me ask you a very simple question. Do you believe that we've lost an opportunity today to, at some level or the other, grant recognition to a number of people who have found themselves on the wrong side of social prejudice?
See, NCPCR's intervention is very limited in this case towards the question of adoption by the same-sex couple. And as we presented in Honorable Supreme Court, India relies on Hague Convention of Adoption as well as United Nations Conventions Right of Children in both instruments, both international instruments. There is no mention of adoption by the same-sex couples. By relying on these international instruments, our Juvenile Justice Act and the adoption regulations, which are in the line of these international instruments, there is no space currently in the country to allow adoption by a male to of a female child or by a same-sex couple, because there is no mention of this kind of adoption in international laws. So we are bound by laws. We just presented all these facts to the Honorable Supreme Court, and we are happy that Honorable Supreme Court has given indulgence while passing this verdict today. I am glad, I am happy, and it is in the best interest of children of country.
You said best interest of children of the country. Why do you say this? Is it because same-sex couples subscribe to a perhaps less robust moral code? Is that what you're saying?
See, the entire world is bound by some rules, some regulations, which are international instruments, and we all are bound to abide by them. If there is no mention of such kind of adoption in international treaties or in global conventions, then it will be quite difficult to adopt this kind of,
no, but Mr. Kanungo,
adoption processes.
You used a phrase. I'm actually coming back to that phrase. I want to understand that phrase better, because there are countries, of course, where same-sex couples are allowed to adopt children. So I want to ask you, sir, you said it is not desirable. Why is it not desirable? Can I understand that from you?
See, you name the country. I have the name of countries where this kind of adoptions allowed, but they are not signatory of UNCRC. India is signatory of UNCRC, and in UNCRC there is no mention of such type of adoption.
Okay, but you talked about the
I
desirability.
can name you the countries.
Mr. Kanungo, you talked about desirability. Can I ask you, why is it not desirable? Forget about what the convention says. As the NCPCR chief, do you believe, sir?
No, you can't. You can't forget. You can't forget the conventions, because there are many consequences. If a couple adopt a child, they have to travel abroad also. They can. In current scenarios, we are bound to rely on international treaties in cases of adoption, because India is a proud country which has signed Hague Convention on Adoption, and inter-country adoption is also allowed in the country. So we have to be bound by the laws, and there is no mention in the law. That's it.
Okay.
That's why it is desirable.
I only asked you because you used a subjective criteria, desirability, which is very elastic, as you know. So that's why I asked you this question. Thank you, Mr. Kanungo, for putting this into perspective for some of our viewers. Let's open this up. Let's test this entire proposition. Let's open this up. Let's ask some questions. Karuna Nindi, I have to ask you this question because, look, there was, and you would have to admit, a lot of hope. We've seen some amount of progress in the history of gay rights in this country, and some people have found that to be quite astonishing given the baggage that we have carried in the past. So perhaps the time had come, many people had felt that the Supreme Court, under a Chief Justice who has committed himself to inclusivity, etc., perhaps this would have been the right time. Do you feel that we've missed an opportunity here?
That's very well put, actually. I think this is a historic opportunity that has been missed. I will also say that we have not gone backwards. At the same time, there are some gains. Now, transgender people of the opposite gender can marry under the Special Marriage Act. This is something that was recognized in the judgment of Arun Kumar that we had submitted, that passed by the Madras High Court. In addition, the Chief Justice has passed very clear directions to protect LGBTQIA couples against. And so, sorry, there's something going on in the background. Is that your video?
Are you hearing a voice or something? Is that?
I'm hearing your video parallelly in Hindi, maybe.
Okay. Can we just separate the beams? I think we've got some feedback going into Ms. Nandi's earphone. Can that be taken care of?
Thank you. I appreciate that.
Okay.
Essentially, so these directions have also been passed, and I'm reading the judgment now. It only came through a short time ago, but from what the judges pronounced in open court, it appears that 3 judges, at least, it appears 4 judges, in fact, agreed that transgender couples of opposite genders their marriage will be recognized under the Special Marriage Act, and in addition, the protection from criminal case harassment to criminal cases will be ameliorated through the directions that were passed today. However, I do want to say this, that today it has been made clear that the furtherance and protection of queer rights is desirable and important by all judges. This was made clear. The recognition of queerness, in fact, in the judicial domain has been made clear. There was discussion earlier of same-sex marriage, and in fact that was trending all over on Twitter. People were talking about it. There was some counsel in court who were only focusing on same-sex marriage, and a number of us made clear that this does not include non-binary persons, it does not include trans persons, and the court has squarely addressed the fact that trans rights and queer rights are front and center. Now, the fact that the ball has gone back into the court of the legislature, we came to court in the first place because the legislature has failed over a long period of independent India to do anything about this. However, now that the ball is in the court of the legislatures, let us remember something very clearly, that the state legislatures also have powers. In the concurrent list, in the state list, there are powers that they have through which they can pass legislation, they can pass orders, they can pass notifications. And if the opposition parties are going to stand in support of the rights of queer citizens, then let them put their votes where their governance is. Let them pass. Perhaps all that is needed is a government order or a notification to say that the family or the partner of a queer person whose natal family has abandoned them, but whose partner and a marital-like relationship has stood with them and they have chosen them for such a situation, that person then makes decisions for them when they are incapacitated medically, for example.
Right.
That the default situation, for example, I mean, there's a lot that can be done. And that is something I think that has to happen now on very fast.
Well, the tragedy is that a large number of political parties, whether the one that's ruling or in the opposition, they have constituencies, and some of them are thought to be very conservative, and we know that that sort of, unfortunately, sometimes those compulsions, that compulsion tail wags the larger body politic, and that's really where the matter is resting right now. Thank you, Ms. Nandi. Just stay on with me. I just want to open this up and bring in also Hitesh Jain as well as Jesai Deepak. Your reaction, Jesai Deepak, to the Supreme Court judgment?
I'm just happy about the fact that the Supreme Court has stuck to the doctrine of separation of powers. Despite there being certain disagreements within the opinions of the bench on certain other aspects, on the broad question of separation of powers and deferring to the power of the legislature on such policy issues is a welcome move, and this is long due according to me. So that's the silver lining, according to me, of the judgment on a big picture issue. And second, I think on the question of the ability of non-heterosexual individuals to adopt children, I think there is a disagreement between two sets of opinions. The majority opinion on the subject is led by Justice Bhatt along with Justice Narasimha and Justice Kohli, whereas the Chief Justice along with Justice Kaul has taken a different position, that it should be possible for non-heterosexual individuals to be able to adopt children. The majority opinion, of course, prevails in this regard. And the third one is the question of how does the legislature and the executive, or how do they take it forward by constitution of a committee under the stewardship of the cabinet secretary to address certain operational difficulties, such as whether it's possible for people in non-heterosexual unions to have common ration cards, or can they nominate each other for insurances or bank accounts, so on and so forth. These are the broad takeaways. I'm certainly happy with the overall tone and tenor on the question of non-interference with the legislative policy.
Okay, Hitesh Jain, let me bring you in, and do try to stay on with us a little longer than your cutoff time of 7:30, because this is an interesting and very, very important
Rahul,
issue.
I will have to excuse myself.
Okay, can the Parliament,
because
can the Parliament, Hitesh Jain, can the Parliament be expected to take a compassionate view when it is so mindful of constituency pressures in the main?
Rahul, to answer your question directly, Parliament can take compassionate view, and even the government took the compassionate view before the Supreme Court. The government at the outset made it very clear to the court that this is not a matter where they are for or against the LGBT community. The government also acknowledged and respected the rights that flow from the judgment of Nalsa and Navtej Singh, and they categorically mentioned before the court. Now, what had happened was the reliefs that were claimed by the petitioners, it was completely misconceived. The arguments were purely based on rhetorics and platitudes. Now, as far as what the petitioners wanted to do was, wanted the courts to enter into the domain of the domain. Can someone,
Karunanandi, he didn't interrupt. Please, let him finish his point.
So
you can
basically what had happened was, the petitioners wanted the judiciary to enter into the domain of the essential functions. So the Supreme Court very clearly said that they respect the essential functions of one arm of the state, and they cannot enter into the essential arms. As far as the marriage is concerned, now see, we had Navtej Singh, we had Nalsa, we were speaking about the rights, and everybody, as a lawyer, we were consciously aware that the reliefs that were claimed, they have to be ultimately flow from the legislature. Judiciary, by one stroke of brush, by asking that section 4 should be declared as unconstitutional, you are not going to get the results. There are like around 160 other acts that were depending on that one amendment. There were personal laws were concerned. It required an interplay between various legislation. So you cannot short circuit everything and go to the court and ask the court for the reliefs. Essentially what the petitioners were doing, they were saying you brush everything under the carpet, you just declare section 4 as unconstitutional, and then the rights will flow. So basically the courts have plugged at that, the courts have looked at it. This is not an issue where we have to look into and hurry or look at some overnight, some resolution will come. I think we have made a progress. The courts have recognized the right of queer. It is not a foreign against the LGBT community. The rights that have been flowed in Navtej Singh have been respected, and I am sure that as a society we will make a progress from here.
Progress from here, but you said that the petitioner might have been, I'll just come back. Let me just explore that point that he made. Then you can give a substantive rebuttal, Ms. Nandi. Let me just ask you, Mr. Jain, you said that the petition itself might have been misconceived. Why?
Well, I think what they were basically asking was the courts to grant the statutory right with respect to marriages and various other rights are concerned. Now, as far as marriage is concerned, adoptions is concerned, or the civil rights that will flow from the union is concerned, I mean, you are looking at the whole host of, gamut of personal law, all the other acts that are flowing, Fatal Accidents Act is concerned, you look at the Dowry Protection Act, you look at the Domestic Violence Act, there are a number of legislations. Now, can by one brush the Supreme Court says that okay, we will make the law and enter the domain of the legislature, it would have done more harm than good. So I think I appreciate. I mean, like Ms. Karunanandi said, they have waited for so many years. But certainly, you have to, if you have waited for so many years, you will have to have more patience and develop an opinion. You have to create a dialogue, build a consensus, and the right forum will be the legislature and not in the court. If you want to build a dialogue, nobody says don't have the dialogue. Nobody says we should not have a consensus. But the correct forum is the parliament.
Correct forum is the parliament. Ms. Nandi, respond please. You're on mute, I think. You might be on mute. Yeah.
Whenever there is a judgment, there is great glee given in our polarized society and in polarized societies around the world, where many people sort of pop up in happy celebration. Now, let us look at what these judgments actually say. And I quote, "The Constitution of India expressly authorizes judicial review. While doing this, the Constitution confers broad powers on this court, as discussed in the previous segment of this judgment. This being the case, it is injudicious to borrow from the jurisprudence of the US on judicial review, its boundaries, legitimacy, and the types of cases which warrant deference to legislative bodies. In the state of Madras versus V.G. Rao, a constitution bench of this court held, we think it right to point out that it is sometimes overlooked that our constitution contains express provisions for judicial review of legislation," right? Now, they then cite Romesh Thapar, and they also say that arguments of this nature seek to strike at the legitimacy of the judiciary and are therefore unwarranted. So hence, the fact that they went into this matter is not something that is a problem in any way. This was very much in the ambit of what the court is set up to do, to see whether an issue like this falls within the bounds of the Constitution or not. Let us also remember that two judges said that while there is no fundamental right to marriage, there are various concomitants of marriage and the various aspects of marriage that fall within Article 21, that fall within Article 19, and that are within various constitutional rights. Also, people like Mr. Jain perhaps are unaware of the fact that it is not merely the striking down of Section 4 that was sought. There were many other arguments that were made. Arguments were made, for example, to say that Section 15 to 18 are effectively a code in themselves and do not anywhere mention gender, right? Nothing needed to be read in, nothing needed to be read down. And that could have been applied. This is why I personally believe, and of course I was arguing for two sets of petitioners in this case, so that is very much where I am located. But I certainly believe that this is a historic missed opportunity, in particular with regard to adoption, where there is a very clear and strong decision by the Chief Justice and the second most senior judge of the Supreme Court, where had one judge supported the decision, these families would have had the legitimacy and the children would have had the rights, and the Child Rights Convention places the right of the child as the primary consideration.
Sure. Karunanandi, I just want to ask you this, because there are also a whole raft of personal laws that militate against unions such as this, and you know
absolutely
perhaps the reasons why. And the Supreme Court said, we're tiptoeing around this, we're not getting into this. Do you think the Supreme Court, well, the reason is because the Supreme Court in the past has been selective about which religion's personal laws it wants to sort of look into, so to speak. That's why I was sort of saying, was this a missed opportunity? Did the Supreme Court sort of, sorry to use the word, and I hope they don't come down on me, and if they do, you could please defend me, have they sort of weaseled out of this?
Well, there are many ways to say the same thing in a more polite way, and they certainly won't come down on you. But look, the Special Marriage Act is a bit like a uniform civil code, right?
Yeah.
It's an opt-out. It's already an opt-out. It was designed as an opt-out so that people of religions, that people who didn't want to get married under religious law,
True.
people from different religions, people from different castes could be married. The objects of such laws have been found by the Supreme Court in a number of judgments to have the potential to be interpreted in a way that is more expansive than some of these judgments interpret. This law, right? This law could have, in my personal view, have been interpreted in that manner as being something that was an opt-out, and therefore sections 15
But
to 18.
what would happen if there were two individuals who didn't want to opt out? They wanted to stay within the domains of their religion, wanted to, they might have had an inclination to stick within their religion. Why would...
Absolutely. And those arguments can be made. Look, there's Article 25, there's Article... And those arguments can be made. But very early on, it was discussed and sort of across the bar and bench. And it was effectively decided that personal laws would not be gone into. So that if just the same-sex, the Special Marriage Act and the Foreign Marriage Act and a few other of the concomitant acts could have been, in the Special Marriage Act, the reading down was not even required,
right.
But the Foreign Marriage Act would be required to be read down,
okay.
Then that could have been done.
Well, viewers, you see, had perhaps the issue of the UCC not been politicized so much, we might have actually made progress today, had we had one. But let's bring in J-Sai Deepak on that particular point. J-Sai Deepak, fact of the matter is that many people, especially petitioners, and some of those who appeared for them, were hoping that perhaps, we would have a breakthrough today. As Karunanandi said, that we could have seized the moment, made most of this opportunity. Do you feel that the endeavor has been defeated now, or the court has accepted its own limitations?
So first of all, I don't think the court has taken a position contrary to the interests of the petitioners and the cause that they represent.
Right.
Two, the doctrine of separation of powers is not a convention. It's a very clear line drawn in the sand within the basic structure of the Constitution. So the court itself, as an institution that respects constitutional morality and as an institution that is expected to set an example to the rest of us, has done the right thing by painting within those lines. But most importantly, having stayed within those lines, the court has done its best in terms of expressing its support for the cause, clearly laying down the fact that even non-heterosexual unions must be accorded dignity by the society and by the state, and by coming out with detailed directions to prevent police harassment of any individual on account of their non-heterosexual gender orientation, or rather gender identity or sexual orientation. It has also come out with detailed directions to the government on what aspects it must deal with as part of the committee that has been proposed and which the government has undertaken to constitute.
Okay.
So I don't think this judgment has failed on the aspect of taking the discussion forward.
Okay.
All it does is that it says, I am with you, but there are certain things that fall outside the remit of me as an institution.
Okay.
And therefore, this is for the other arm to take it forward. But to the extent that I can recognize your existence and your right to live with dignity, I will do so. That's what the bench has done across the board.
Okay, but let me ask you, the parliament has not always gone along with what perhaps could be considered fair and strictly, in jurisprudence terms. Now, we have the Shahbano case in 1985, etc., and you saw how that sort of ended up.
There's an answer to that question, which is that if you take a look at the tone and tenor, and of course I don't speak for the government, nor do I hold brief for it in any way, professionally or otherwise. But if you see the tone and tenor of the government during the course of its submissions, it is the government that specifically said we are happy to constitute a committee, we are happy to look into operational difficulties, but we also have to look at larger issues, because the clear submission was that marriage as an institution has an ecosystem of laws, close to 700 legislations, each of which would have to be considered from the perspective of what would the recognition of this relationship translate to legally speaking. From protection of women or protection of individuals against domestic violence to child support to maintenance and whatnot, each of those questions have to be answered. It's not for a court to sit and ask itself, if I were to recognize this species of marriage within the meaning of the Special Marriage Act, how do I undertake an amendment or creative interpretation of 700 other legislations? That's not the mandate of the judiciary at all. This is practical, this is policy based, this is legislative, there's so much to this. Which is why to reduce this issue purely to one of dignity and consent is to forget the fact that as a state you have larger responsibilities. And that's not to say that individual rights must be ridden roughshod over. But the court as well as the rest of the institutions have an accountability to the larger society.
Okay.
And nowhere have I seen any institution, whether the legislature or the executive or the judiciary, taking a position against non-heterosexual interests. If anything, this is an institutional limitation. It's not a mental limitation.
Okay, well, we've heard a very well-rounded debate, viewers, different points of view, shades of opinion coming into this. We'll take a short break. When we return to an alarming development which needs to be examined. Stay with me.
Hello, Moto.
Electricity bill.
Gaza Strip, because of the number of casualty that has been going on there, humanitarian crisis that has emerged, food supplies shortage, medical supplies shortage, doctors having been killed, children having been killed. So the gory images of Israeli tragedy, and that is where the balance of geopolitics remains. We'll have to see whether the Israeli offensive will continue on the Gaza Strip or the diplomacy will take center stage, and there will. We are in Zerot, and this was the place which was worst hit during the 7th October terrorist attack by Hamas people. We are joined by Erith, and she will explain the kind of situation that is currently in city. Okay, so first to just give you some idea, we are still standing on the splattered blood remains, and this is a safe house that was probably also attacked, and many people were dragged out of this house and killed summarily. So Erith, how would you describe the situation in the city currently?
So right now we have about 4,000 to 5,000 people that stayed in the city. The rest of them have been evacuated, and they're living either with family outside of Sderot or in hotels. The government and the city is providing for them, making sure that they have everything that they need, from mental health support to clothing and food and provisions and anything that they need. And right now we're trying to take care of also, we have people on the ground from the municipality in every hotel, and trying to see if there are any needs that come up, and whatever people need, we're taking care of.
So we know that on 7th of October there was total rampage and mayhem that was done by the terrorists.
Right.
I mean, if you could describe how the situation in the town on that day, how did it all
So what happened that day?
Yes,
so really, it's 6 o'clock in the morning, sirens went off, and when sirens go off, people hear no to go into the shelters. Because it was a holiday, people were supposed to be walking, to synagogues that morning, and it's a Saturday. But because of the sirens, people weren't on the streets, thankfully, because the minute that happened, we had a few jeeps. I do not know if it was 3 or 4 jeeps, heavily equipped with military and equipment, guns, explosives, you name it. And they just went through town, through the main street, and then they separated into a few streets. One of them came to the police station that we see the remainings of right here, and they took over the police station, and the rest of them were just going around town and killing anyone that they could. Anyone. People were shot in their cars. There was a minibus here with people that were going on a trip for the day. They shot all of them, all 13 people in the cars. They were just running around trying to kill people as they go. The police, the minute the police was able to do something, they did. The minute our security team, the minute they heard anything, gunshots, whatever that was, they put their gear on and they went to the streets to actually look for these terrorists and to have some kind of a face-to-face with them so they can finish them off. But it was brutal. They came very prepared. They knew exactly what they were doing. And the minute they got a hold of the police station, they got the higher ground. And there was a sniper or two snipers on the top of the building, and they were really killing anybody around you. Now you can see this is a populated area, so people were stuck in their homes.
Elith, how many hours it took the security forces actually before they could take control of the city entirely?
So it took a long time, because you have to understand the army was surprised as well, and the army was on fighting the front line of the kibbutzim and the moshavim.
As Israel continues the offensive to flush out Hamas terrorists and cripple the nexus between them and other global jihadist organizations, days after the deadly terror strike that has claimed over 1,000 Israeli lives, Iran's supreme leader Ayatollah Khamenei has now warned the Jewish state and its allies, saying there will be a global jihad if Israel does not stop its crimes in Gaza, that all sorts of resistance, quote unquote, resistance leaders will hit the streets all over the world and overwhelm those that are standing with Israel. Iran has long been suspected of providing logistical and military support to Hamas to carry out the ghastly crimes in Israel as the hostage crisis continues. Israel is currently planning a ground operation in Gaza in its mission to end the Hamas network, but could the conflict escalate as Iran saber-rattles on the other side? Let's ask some of those questions. I'm joined by Charlotte Littlewood, Research Fellow of the Henry Jackson Society. Thank you very much for speaking to me. Now, one can understand that some Palestinians fed on a continuous diet of bigotry by Hamas could develop Israelophobia or anti-Semitist outlook. But what root cause could force, for example, British Muslims to enlist in this global jihad that Iran promises and support Hamas and what it stands for? And we've seen protests, of course, in England, in Britain. What do you think it is that drives this bunch?
First of all, just quickly, I'm head of the UK India desk for the International Centre for Sustainability. I no longer work at the Henry Jackson Society, just a quick correction. So the ideology that we're talking about here, its roots are before Khomeini, before Hamas. We need to look back to actually Maududi in the subcontinent, now in the area known as Pakistan, and his ideology in opposition to British colonialism. It was in his works writing about advocating for pan-Islamism and the Islamization of the state, in opposition to what he feared was British imposition on Islam. That inspired thinking that spread to one of the most important ideologues underpinning all that we see with Islamic jihad in the world today, and that's Qutb from Egypt. And he wrote a very important book for Islamic jihad, that being Milestones. Now, Milestones was translated by Khomeini into Persian for the sake of his ideology there. And he's deeply anti-Semitic, Qutb. He sees Jews behind all problematic revolutions as he sees them, including the fall of the caliphate. And this thinking has developed into a want to remove all Jews. And you see that being drawn out from interpretations of one of the hadiths in which it calls that the end days will not come until the Jews are eradicated, and Jews will hide behind stones, they'll hide behind trees, the stones and the trees will turn around to them and say a Jew is here and a Muslim will kill them. This intermingling of thought really does root back to Maududi, then Qutb, and Qutb has inspired Khomeini. So you really have to understand this. You have to understand the context as well. This was against British colonialism for Maududi. It was against secularism for Qutb. Qutb had spent some time in America. He was disgusted by secularism in the West. And he created an idea that took Maududi's ideas further. And he said there needed to be violent, offensive jihad to bring about Islam across the globe. And until then, there wouldn't be peace and there wouldn't be goodness on the earth. And he really, that thinking and his book Milestones are considered to be the linchpin of Islamic fascism across the globe as we see it today. And it is that thinking that comes through various groups and inspires the responses that we're seeing in the West.
Now, Charlotte Dilwood, what you're saying, anyone who follows this sort of strand of thought would sort of be acquainted with. And I'm sure that a large number of government officials in UK, in France, in Sweden, in Belgium would have known that fundamentally this is what sort of drives a particular strand of thought and society amongst Muslims in various Western capitals. Why wasn't this addressed?
We have a really problematic history with addressing this threat. So this Qutb was a part of the Muslim Brotherhood founded by Hassan al-Banna in Egypt. And we have various organizations with Brotherhood links. We have individuals that came from Egypt and set up these organizations in the UK. And the Muslim Brotherhood actually directly worked with the UK government at early stages to tackle violent jihad and violent Islamism. And I think it was these early mistakes of working with Islamists to tackle violence was very problematic, gave them platforms, money, influence. Another thing that we've seen in the UK is a real fear to engage with tackling Islamist extremism for fear of being called Islamophobic, a lack of faith literacy to understand that Islamism does not represent all of Islam, and moderate Muslims, in fact, are working to counter Islamist extremism. And the UK government has failed to really provide allyship to those Muslims and has instead provided room, space, platforming for Islamists. It has tried to change this tactic in latter years, but almost too late. And influence and infiltration has already happened. And the pushback from these groups, both legally suing anyone who tries to talk about Islamist extremism, politically pushing back, there's an element to which we have communities that will vote according to certain directions, which causes those in political positions to be shy on this topic. But then there is the issue that we see across the West of people being worried to engage. Right. And that really came to a head with our Manchester Arena attack, the Ariana Grande concert that was attacked. The guard actually at the Ariana Grande concert didn't call in the threat. He saw the terrorist with the backpack in the hallway, didn't call it in because he was afraid of being considered extreme or racist. And so he took himself outside of the building and guarded the bridge for a while.
Well, it's called appeasement here, of course, in India. And that's what's also cost us, viewers, as you all know. We leave it at that. Thank you, Charlotte Dilwood, for putting this into perspective for us. Of course, President Biden tomorrow is going to show up in Israel, and that could pave the way for a full-blown invasion of Gaza. What will that mean? We'll be interrogating that question tomorrow. Don't go away.
So, really in Sderot, by the time we got the help and by the time we got a hold of the situation, roughly 36 hours, which is a very long time to be home and scared. I got a lot of calls from people calling me and saying there are gunshots by my window, there are gunshots in the streets, not knowing if it's soldiers or if it's, Hamas. So it was very, very scary.
With the kind of city and the situation, how soon do you think the city can go back to normal, people can come back and they will live?
Listen, I'm not a prophet and I have no idea what the government is planning. I do know one thing, that the mayor of the city is already planning ahead, and they understand that in order for us to be able to recover, the minute the military operation ends, we have to be prepared for our people. And we're going to do anything and everything that we need to in order to do that. So we're raising funds right now to be able to rebuild our homes. There's so many homes that have been hit, about 74 direct hits into people's homes. Some people have nowhere to go back to, right? So we're going to be able to rebuild it. We're going to be able to give them what they need when it comes to mental health professionals that are in town, anything and everything. And right now they're getting ready for that. So the minute we'll know that the operation or the war is over, then we can start with the recovery piece.
A few days.
We don't know. I think everybody's kind of preparing us for at least a month. Yeah.
So, thank you, Eric, for talking
you
to
very
us.
much.
And it may take probably few months before situation would go back to normal. And situation has been pretty bad. We have seen all around the city, the blood-soaked streets, houses, they have been left like that, cars burned. Behind me, you could see there was a police station that used to be here. And what is left of this police station is all that a small puddle of water and rubbles. Those were removed from the site, just days before. Now the entire city, it looks ghostly. The cars that were attacked, and they were actually, totally damaged. People at home shot dead. It was a day of rest. People are not very hopeful about how soon the normalcy will return in the city, but they do hope that probably it will take few weeks or few months before the situation could be as safe and secure that people who have fled from the city would be returning back to their home. Meanwhile, the entire city and the perimeter of the city has been taken over by the Israeli Defense Forces, tanks, artilleries being fired, Israeli jets also flying over Gaza and dropping ammunition or missiles targeting Hamas locations. 2,400 or more than that people in Palestine, in Gaza, they have also been killed. Swiftly shifting towards the humanitarian crisis that is emerging in the Gaza Strip because of the number of casualties that has been going on there, humanitarian crisis that has emerged, food supplies shortage, medical supplies shortage, doctors having been killed, children having been killed. So the gory images of Israeli, Israeli tragedy, and that is where the balance of geopolitics remains. We'll have to see whether the Israeli offensive will continue on the Gaza Strip or the diplomacy will take center stage, and there will. We are in Zerot, and this was the place which was worst hit during the 7th October.
Good evening, hello and welcome. You're watching The Right Stand here on CNN News 18 with me, Poonam Burde. Before we get into the big debate tonight, let me take you through some of the highlights of the day. Prime Minister Narendra Modi chaired a high-level meeting today to review the preparedness of India's Gaganyaan mission. He also outlined the future of India's space exploration endeavours. The Prime Minister directed that India should now aim for new and ambitious goals, including setting up the Indian space station by 2035 and sending the first Indian to space by 2040. Prime Minister Modi inaugurated the third edition of the Global Maritime India Summit in Mumbai today via video conferencing. The summit will discuss and deliberate key issues as far as maritime sector is concerned. Prime Minister Modi also launched maritime projects worth 23,000 crore rupees that are aligned with the